Good afternoon, everybody. It is Friday, September 25th, 2020, and it is noon. So we will get started with our September meeting with the Lee County Bar Association, presenting today on the corporate court interpreter at your service. My name is Matt Repsdorf. I am the president of the Lee County Bar Association. So everyone knows we are recording today's presentation, and it will be made available if you could not attend live. It will be made available on our YouTube channel and by request. We are also going to be eligible for CLE credits today. So if you are registered or if you decide to watch this at a later date, please make sure and sign up or get information for CLE credits when those are issued by the Florida Bar. Today's presentation is, frankly, a pretty interesting one, dealing with court reporters and court reporters at your service. We are joined by Leon Fontova, who's the supervisor for the court interpreter department with the 20th Circuit Judicial Circuit here for us. It's obviously a new world that we're still figuring out with Zoom hearings, conference calls, remote work, remote calling in, and only certain live hearings be allowed to take place and be conducted. So if you're doing a remote hearing and not all of us have English-speaking clients and you are servicing an English-speaking client, how do you set up or how do you administer your interpreter via Zoom or via remote? So Leon is here to help us out with that and walk us through that process. A little bit about Leon. Like I said, he is the supervisor of the court interpreter department for our 20th Judicial Circuit. He's been there for over 12 years as a Spanish court interpreter. And if you've been in the courthouse anytime in the last 12 years, you're bound to see him. He's all over the place, jumping from courtroom to courtroom usually, and being a great help to us all. He's served the U.S. District Court for the Middle District of Florida for almost a decade. He's got education in the field of interpretation from University of Arizona, the National Center for Interpretation, Court Interpreter Training Institute, a certificate in translation and interpretation program at FIU. He's been doing this for a long time. He's great at what he does, and we're excited to hear what he's got to present for us today. So without further ado, I will turn the presentation over to Leon Fontova. He's going to tell us all about corporate interpreter services, especially in the age of COVID here. So thank you, Leon.
Thank you very much, Matt. I appreciate that very kind introduction. On behalf of the Administrative Office of the Courts for the 20th Judicial Circuit here in Florida, I'd like to thank the Lee County Bar Association for inviting us to make this presentation. And it's our hope that it's going to be informative and useful to the members of the bar, especially when working with court interpreters. I'd like to begin by introducing Lisa Fletcher. She serves as the Chief Deputy Court Administrator for the 20th Judicial Circuit, and she'd like to address us before we begin. Lisa?
Thank you, Leon. First and foremost, I want to thank the Lee County Bar for this opportunity. We do think that it's very important to just understand the process a little better and improve the communication. So we are grateful. Thank you, Lauren, for facilitating this. And thank you, Leon, for all of your hard work in putting this presentation together. On behalf of our trial court administrator, Scott Wilsker, we value the partnership. So thank you.
Thank you very much, Lisa. So I'll begin by sharing the presentation. There, and I hope it's now on your screens. The court interpreter at your service. We're going to see an overview of the points that we're going to be covering here today, and how we can better serve you and we work with you in our role as court interpreters. So we'll consider the role of the court interpreter. What does that entail? What does it not? What is the code of professional conduct that you can expect court interpreters to adhere to, and why is it important also that you be aware of what's expected of us? The court interpreter certification process and why it's important to protect the rights of those who come before the courts and those whom we serve. Working with the court interpreter we'll touch on some of the things that that can be done to make sure that the work of the court interpreter is accurate and complete. We're going to discuss, as Matt mentioned, the technology and court interpreters, and something that's become very important here recently, as we know. And we'll touch on some of the things that we do to schedule court interpreters, and that way you can make sure to always have one when you need one. And finally, we'll turn it over to answer your questions. If you'd like to submit your questions during the presentation via the chat function at the end, then we'll be happy to address those as time allows. So what is the role of the court interpreter, and why is it important to understand that role, what it is and what it's not? What are the different modes of interpretation? What are some of the common misconceptions? Well, the foundation for providing court interpreters legally is based on the Title VI of the Civil Rights Act of 1964, the Court Interpreters Act, the federal 28 U.S.C. 1827, Section 90.606 of Florida statutes, and the Rule 2.560 Florida Rules of Judicial Administration. So these are the laws that enacted or gave way or rise to the court interpreter certification programs at the federal level and at the state level, and that regulate the services of the court interpreter. The reason for these are to assure that the person who comes before the court who has limited English speaking ability can have equal access to the courts. And the description that's provided in this presentation is, although its focuses on the state courts and the state court rules, and it also applies in principle to the federal courts as well. So Florida 2.560 Rules of Judicial Administration provide that an interpreter will be provided by the court in any criminal or juvenile delinquency proceeding. And as the language there states, it's to provide the defendant or the parent or legal guardian of a juvenile or a victim who comes before the court, or even an alleged victim, when they cannot understand or cannot be understood in the English language, then the court will provide an interpreter. Now, for other types of cases, the rule provides that an interpreter will be provided when, if you notice at the end of the paragraph there, when a fundamental interest is at stake. And then it goes on to describe what that would be, such as civil commitment, termination of parental rights, paternity or dependency proceedings, and when there's no alternative to the appointment of an interpreter. So when the court determines that the fundamental interest is at stake, a court interpreter will be provided by the Court Interpreter Services Department. Other types of hearings where there is not a fundamental interest at stake, perhaps a civil action, a divorce proceeding, or civil traffic, a court interpreter would not be provided at state expense by the Court Interpreters Department. But arrangements could be made so that the parties have their interpreter, and the Interpreter Services Department is happy to provide a list of interpreters who may be available, so those arrangements can be made by the interested parties. Now, what does the court interpreter do? The purpose of the court interpreter is to allow a defendant or someone who becomes before the court who's limited English proficient, and that's a term that's used in the profession. The acronym is LEP. It enables them to exercise their constitutional rights, including the right to be present, not just physically, but linguistically present. The right to counsel and to be able to communicate with counsel and aid in their defense. The right to confrontation, to hear what witnesses are saying and to be able to question them and confront them. The right to be informed of the charges and understand the nature of the proceedings. So the purpose of the court interpreter is to preserve these constitutional rights for limited English speaking individuals. In our profession, we refer to it as equal footing. What we do is place a person who either does not understand English or does not understand or speak English well enough to be able to communicate effectively. So with the assistance of an interpreter, a person who is limited, has limited English proficiency will hear, and this is the goal, will hear as though they were English speaking. Will be able to communicate and express themselves as though they spoke English. It puts them on equal footing with an English speaking person in the same situation. So the goal of the interpreter is not to give anyone an advantage or to explain or to do anything more than simply put them on equal footing with an English speaker in the same situation. For that reason, the interpreter is not an advocate, not a friend, not there to explain anything. We are a neutral party and we simply interpret. That's our role. And one of the rules in our profession for this reason is what we call the rule of three. It takes three to interpret. We need the limited English speaking individual, the interpreter, and then that third party for whom we're interpreting. It could be the court, an attorney, the clerk, a bailiff, but there always has to be that third person. That's why you'll never see or should never see the interpreter alone with the person for whom they're interpreting. And as we'll see in the Code of Professional Conduct, it's not something that that we should do. What is that Code of Professional Conduct? And what does it include and why is it important for you as attorneys to know? Well, the Code of Professional Conduct in the state of Florida consists of 10 points, and it reflects also the Code of Professional Conduct at the for federal court interpreters, as well as the same code for other states. And the 10 points that we'll cover here so that you are familiar with them is start with the first point, professional conduct. Well, as interpreters, we're sworn to uphold this code. And the first point is that we will do just that. The second point is extremely important, as you know, accuracy and completeness. Interpreters shall render a complete and accurate interpretation or sight translation without, and notice, without altering, without omitting, without summarizing, or adding anything to what is stated or written, and without explanation. For there to be a complete and accurate record for a person's rights, constitutional rights to be protected, the interpreter must interpret completely and accurately. And this is where interpreter training and experience come into play, as we'll see in just a moment. The third point is representation of qualifications. It goes beyond saying that an interpreter must not exaggerate their qualifications and certainly not minimize them either, but they will accurately report what certification they have achieved, what registration they have achieved, what their extent of their education and training and experience, so that they can be employed to the proper degree depending on the assignment. Number 4, impartiality and avoidance of conflict of interest. This is an obvious one, but it has many subtleties. So interpreters are impartial. We're a neutral party. We're not part of the defense. We're not part of the prosecution. We are an impartial party only there to assist in the communication. Now, if there's a real conflict of interest, which may include if the interpreter has an interest in the outcome of the case, obviously that is a real conflict of interest. The interpreter would need to recuse himself or herself and advise the court. Another common conflict of interest that could arise if the interpreter had participated in an earlier part of the proceeding, perhaps in the investigative part of the action. The interpreter would need to disclose that, and the parties would need to know, and perhaps the interpreter would be replaced with another interpreter if the parties felt that the interpreter could not be impartial. But it also includes perceived conflict of interest. So, for example, if in court the interpreter is overly friendly with court personnel or with the defendant or with a witness, what would somebody who's looking on think? What conclusion would they come to? Might they think that the interpreter has some bias or partiality towards one or the other side? That's why interpreters are very careful about keeping to themselves and limiting their interactions when in court with those that are present. We have to avoid even the appearance of a conflict of interest. Number 5 is something that you're very familiar with, confidentiality and restriction of public comment. So interpreters, the rule says, shall protect the confidentiality of all privileged and other confidential information. So whatever is discussed with the interpreter present, the interpreter is bound and obligated under oath to this code of professional conduct to keep confidential. But there's another level to this. It includes, as the rule says, they shall not publicly discuss, report, or offer an opinion concerning a matter in which they are or have been engaged, even when that information is not privileged or required by law to be confidential. So even at that level, we do not discuss or disclose anything. So for example, after a trial, if the media is present and approaches the interpreter for comment, the interpreter, because of this point number 5, will politely decline comment. But more commonly, the interpreter might be asked quite naturally by perhaps the defense attorney or one of the attorneys after perhaps a witness has testified. And the attorney might turn to the interpreter and say, so what do you think about that witness? Or, you know, how do you think it's going? Those are opinions and comments which, according to this, we are not to make. So again, the interpreter would politely decline comment because of this point on the Code of Professional Conduct. Point number 6, professional demeanor. Obviously, we comport ourselves in harmony with the dignity of the court, and we try to be as unobtrusive as possible. Our goal as interpreters is to be, we use the word invisible, so we try to be as unobtrusive as possible. Scope of practice is another important point because the rule says interpreters shall limit themselves to interpreting and translating and not give legal advice, express personal opinions to individuals for whom they're interpreting, or engage in any other activities which may be construed to constitute a service other than interpreting or translating while serving as an interpreter. So we do just that. We limit ourselves to the job of interpreting and translating. Sometimes a defendant will turn to the interpreter and say, so do you think this is a good deal? That's beyond our scope of practice. We do not give legal advice. And so the interpreter would limit him or herself to interpret to the attorney, "So do you think this is a good deal?" And let the attorney answer the question. This also applies to, for example, we may be requested to help someone fill out a form or go over this plea form. And although we understand the request, because of this point in our Code of Professional Conduct, we are unable to do so. Again, the rule of three. If there's a third party that's going over the plea form with the defendant, then we are interpreting for them. Or if the clerk or pretrial services officer is helping them fill out the form for the public defender application, then we are serving as interpreters. But this point does not allow us to help them fill out the form on our own. Paragraph number, or point number 8, assessing and reporting impediments to performance. Again, something to keep in mind is, as interpreters, we cannot interpret what we do not hear. So if we're not hearing clearly, someone's speaking too softly or away from the microphone, or perhaps there's background noise, then we must report it and ask for a repetition or ask the court to address the issue so that we can hear. The other point to this is if we were in a situation where there's an expert witness or on a matter that we individually are not prepared for, then the right thing to do according to this point would be to inform the court and allow for a substitute interpreter who is familiar with that level of expertise in that particular area to take over. Point number 9 discusses reporting ethical violations. I think we all understand what that means. If we were ever asked to do something unethical, we would absolutely decline and report it to the proper authority. And then point number 10, professional development. We're committed to increasing our knowledge base and our skills as interpreters all the time. Now, the court interpreter certification program is very important because it sets a standard for court interpreters. And often we hear, well, you know, can someone is bilingual, they speak both languages, they can assist or serve as interpreters. And though that is true that they may speak both languages, does that qualify them as court interpreters? And the short answer is no, not really, because there's great training and experience that's required, that just being bilingual is not sufficient. For example, this Code of Professional Conduct, any bilingual person would not even be familiar with this Code of Professional Conduct. So it is very important to understand what that certification process is. It's not a light matter because a misinterpretation could create much harm and actually have disastrous consequences. And that's the reason why the federal courts implemented a court interpreter certification program, and the state courts have followed suit. Now, the training and experience that court interpreters require include specialized terminology. So they need to understand, obviously, legal expressions, but forensics, ballistics, terms having to do with drugs or whatever other matter come before the court, medical terminology. And so that is something that simply being bilingual will not prepare you for. The other part of this is the interpreting and skills that have to do with translation. There are 3 modes to interpreting. The simultaneous mode, the consecutive mode, and the sight translation. Simultaneous is just that, simultaneous. So as the proceeding is being carried out, the interpreter in a low voice or through some audio equipment is interpreting everything that's being said at the same time that it's being said, just a little lag behind. The consecutive mode is used usually for witness testimony, and it's just that, consecutive. So the party speaks, the interpreter will interpret, the party speaks again, the interpreter interprets again, and so forth, back and forth. And sight translation is the oral translation of documents. And each one of these requires a separate set of skills. So to help us appreciate just how complex the interpreting process really is and why it's not enough just to be able to speak another language, I'd like to invite you to participate in a short exercise with me. It'll be fun, and it's all in English, so no need to worry. But this exercise is called shadowing, and it's an exercise that interpreters routinely do, especially when they're beginning in the same language. What you're going to hear is a recording of witness testimony, back and forth questions and answers for about a minute, minute and a half, and in English. And the objective of this is for you to listen to the recording and to begin repeating everything you hear, word for word. Try not to fall too far behind or summarize. If you do, just pick up where you left off and keep going. And this will give you an idea of what interpreters do when we're interpreting simultaneous. Here goes.
What was going on during the interview?
There was a search warrant being served at the defendant's residence at the same time we started talking to him.
Where in the house was the interview?
The interview took place around a table in what I would call a family room. It was in the back part of the residence.
Were you able to see the other officers conducting the search?
The other officers were conducting the search warrant in different portions of the house.
Were the policemen who were searching the house visible at any time during the interview?
Once in a while, one or more of the police officers could be seen as they passed from one part of the house to another.
How did you happen to talk to Mr. Jackson during this search?
After he was told we had a warrant to search his home, I identified myself to him. I told him I was conducting an investigation related to some burglaries in the area. I then asked if he would assist me in the matter.
What did he say?
He told me he wanted to cooperate and agreed to be interviewed.
Was he under arrest at this time?
No, he wasn't under arrest.
Since there was a search warrant being conducted, how was it made clear to him that he was currently not under arrest and was free to leave at any time?
I told Mr. Jackson he was not under arrest. I told him I did not intend to take him into custody. I also informed him he was free to leave and could refuse to answer my questions.
Did you ever advise Mr. Jackson of his constitutional rights?
Yes, I did. He agreed to talk to me, and I informed him he didn't have to answer all of my questions. I also told him if he didn't like any particular question, he didn't have to answer that question. I then told Mr. Jackson that I wanted to formally read him his constitutional rights from a form that I carried with me.
Did you read him his rights?
I read from our standard Miranda rights card. I then handed the waiver form to Mr. Jackson and asked him to read it. I requested that he sign the bottom of the form indicating he understood it and still wanted to cooperate with us and answer our questions.
So that was the exercise. What did you think? Was it challenging? Possibly for some it would be, especially the first time. So if you find that challenging, imagine what interpreting entails. It's not just repeating the words word for word, but the interpreter has to actually decipher the meaning, find the same words in the target language in his or her mind, then that convey that same meaning, then express it and utter it, all the while continuing to listen to what's coming next. And it's one continuous loop that actually employs about 22 different cognitive skills simultaneously while interpreting. Studies have shown that for this reason, mental fatigue sets in about 30 minutes into the simultaneous interpreting, and it results in errors and omissions on the part of the interpreter without the interpreter even realizing it. So this is the reason why when trials or lengthy hearings are scheduled, you'll see that interpreters work in teams, alternating every 30 minutes. It's really the standard, the national standard, and it's also prescribed by the Florida Bench Guide from our Supreme Court. In addition to that, consecutive interpreting requires other skills like employing memory, note-taking, and sight translation requires other skills as well. So really being bilingual is the first step in becoming an interpreter, but it's just that, the first step. Certification is an important process. And what does that entail? The working with the court interpreter. Well, as you work with a court interpreter, you want to make sure that the interpreter has the tools that they need to provide that second point in our Code of Professional Conduct, a complete and accurate interpretation. And what would that entail? Well, as we'll see, there are a few points that we'd like to discuss here with you today. One is when addressing the LEP, use the first person. Speak to them directly using you. So for example, do you understand what we're talking about, rather than turning to the interpreter and saying, does he understand, or saying, ask him or her if she understands. That third person creates confusion. So speak to them directly in the first person. Speak audibly and clearly into the microphone and at a moderate pace. Again, we cannot interpret what we don't hear, so we need to sometimes even hear above our own voice when we're going in the simultaneous mode. And it's important also to speak at a moderate pace, especially when reading from case law or statute. Reading often is at a much faster pace than speaking, and so it's very dense material, and the interpreter needs to keep up and transfer all that material accurately. So the pace is important. Don't have to speak too slow either, but just a moderate pace. Give the interpreter as much preparatory material as possible in advance of the hearing or during the hearing. Reports, expert reports, lists of witnesses, copies of motions, anything that's going to be distributed to opposing counsel and to the court. Keep in mind the interpreters would benefit from a copy of that as well. Again, the whole purpose is to be as best prepared as possible to render a complete and accurate interpretation. Allow the interpreter a short time to interview any witnesses for whom he or she will be interpreting. And this is important because it allows the interpreter opportunity to become familiar with the dialect or the region that the person is from, make sure that they understand one another, of course, and with you present, the interpreter can explain a few of the principles involved in interpreting for witnesses. So they'll be instructed that the interpreter is a neutral party, that everything that will be said will be interpreted, to speak directly to the attorney in the first person, not to the interpreter, and to wait for the entire question to be interpreted before answering. Remember that court interpreters must interpret everything. So sometimes we're told, well, I'm just going to ask for a continuance. You don't need to interpret that. Well, by the Code of Professional Conduct, we are required to interpret everything, and we will. The other thing to keep in mind is if an objection is raised after the witness has spoken a few words or even sentences, the interpreter is still required to interpret what was said. And so that's what we're required to do for the record. Be sensitive to the existence of cultural and linguistic differences and avoid extensive use of colloquial and idiomatic expressions and acronyms. What does this mean? Well, for example, if a person, if you use an example and say, well, was it about the length of a football field? For someone who did not grow up in the United States or is not familiar with the game of football, what would that mean? Even if I find an equivalent translation into Spanish for that, but would they get the sense of it? Or idiomatic expressions, for example, it was raining cats and dogs. Well, a word-for-word interpretation of this would make no sense, for example, in Spanish. but there is an equivalent idiomatic expression for this. But you have no idea how much time it takes to find that equivalent idiomatic expression. It can be challenging, and the proceeding goes on and on. So it's important that that we avoid, to the extent possible, those idiomatic expressions and acronyms for the same reason. The court interpreter can only interpret, as we discussed before. We cannot fill out forms or relay messages and things like that. The court interpreter is there to serve the court, and we're not really able to step outside for what would be an attorney-client meeting. Sometimes there are matters that are incidental to the proceeding and need to be discussed just in advance of the hearing or just after the hearing and right there in court, and that's fine, of course. We're there to serve. But lengthier or discussions, because we're serving the court, we cannot step outside of the courtroom to do those. Those are best handled in advance of the hearing with a separate interpreter. And court interpreters cannot interpret audio or video recordings in open court. And this is according to Supreme Court guidelines. So if there's a recording, be it audio, video, or both, the procedure would be to contact the court interpreter's office or an interpreter if it's something that we do not provide for, and have a transcription and a translation of that transcription prepared for you. It takes about 6 weeks. It's a very lengthy process, so just to keep in mind. Now, technology and court interpreters. Well, Zoom, VRI, audio equipment, and so much more. This has certainly been a challenge for everyone, and everyone has stepped up to meet the challenge. And most hearings at this point are still being held over Zoom. We have a VRI, or video remote interpreting equipment, through Polycom here in state court, into several of the courtrooms that tie into our interpreter our offices here at the Interpreters Department. And of course, some hearings are conducted telephonically. So what are some of the things to keep in mind when it comes to these remote hearings? One is that the Zoom meeting ID and passcodes, we want to be there, and we want to be there on time. So and it's not always easy to find those meeting ID and passcodes. So as you have them from your notices, please provide them when requesting an interpreter. One on the meeting, it's important that everyone speak in turn, and we've all been getting better and better at this. But especially for the interpreter, when more than one party speaks at a time, again, it's very difficult, if not impossible, to be complete and accurate in the interpretation. Speak audibly and clearly so that we can hear and interpret, and remind your clients and witnesses to speak in turn and audibly and clearly. Now, Zoom has most of the Zoom hearings on Zoom are being conducted in the consecutive mode in interpretation. Because of the nature of the hearings, the number of people that are connected, it really is the only practical way to provide the service. And consecutive, again, is where every party speaks in turn, the interpreter will interpret, and so forth. Now, Zoom does provide a simultaneous interpretation function, which requires a specific setup in advance by the host or the judge or the whoever is setting up the hearing or the meeting. And it also requires that the interpreters be trained in the use of this function, something that the Court Interpreters Department has been working on. And it also entails that the limited English proficient person be trained on how to access the language channel that they will need to access to hear the interpretation simultaneously. So if this is one of the hearings that, if this is one of the functions that will be used at a hearing for one of your clients, then the Interpreter Services Department will work with you on how to get that set up. It's particularly helpful in lengthier hearings, trials or long motions where there are a controlled number of parties involved. Now, the courtroom and audio equipment. In the courtroom, we have audio equipment, a transmitter, receiver that the party will use so that we can communicate with them and interpret without interrupting the proceeding and maintaining a safe distance. Now, how to schedule an interpreter? Where is the interpreter? That's the one question we never like to hear. And we do our very best to make sure that there's an interpreter available whenever they are needed. Now, to keep in mind just a few points on scheduling and how and when to request the services of an interpreter from our department. When it comes to Spanish, because we have several Spanish staff interpreters and many of the cases that we interpret for are Spanish, we schedule Spanish interpreters for the following hearings. For first appearance, always. Juvenile detentions, always. Misdemeanor and felony arraignments, always. Docket soundings, case management conferences, and pretrial conferences. We always check. There's a system that we have here that identifies if someone speaks another language, and if they're on the docket, then we will schedule an interpreter. This is just for the routine docket sounding or case management conference or pretrial conference. But if there's a plea or something that's going to be scheduled at these conferences or docket soundings, then we would request that you submit an interpreter request. And we'll see in a minute how to go about doing that. So you do need to submit an interpreter request form when it's a plea in a misdemeanor or felony case, when it's a motion hearing of any kind, a trial, of course, and even DV injunction for protection hearings, so that we make sure to have an interpreter there. We request at least 24 hours in advance, but the better practice is as soon as you know that a hearing is scheduled for a client that's going to need a Spanish interpreter, let our office know, and so we can make sure that we have an interpreter available. When it comes to all other languages, Italian, Arabic, some of the Mayan dialects, Mam, Quiche, Creole, Haitian Creole, Portuguese, there are fewer interpreters available, and therefore their availability, because they're also serving other courts and even other states, is somewhat limited on short notice. So we require or request at least 7 days notice, but even more is better for these other languages. And that's for all hearings because of the resources and the scheduling challenges. We need to know from you if someone's going to be present and they're at an arraignment and require this, for example, and require the services of the interpreter. For attorney-client meetings, depositions, and other events outside of court, those are arrangements that that you would make with the interpreter directly, and our office is happy to provide a list of interpreters or available interpreters in the area as a courtesy. Just contact our office and we'll be happy to provide that for you. Now, how to request an interpreter? Well, there's our 20th Judicial Circuit homepage. To the right, you'll see where it says request a court interpreter. And that opens up this page. If you click on court interpreter request form, it'll open up the form for you. And it's just the basic information that we need: case name, case number, the judge, the courtroom, the Zoom meeting ID, and so forth, and the date and time. And this actually feeds directly into our scheduling system. And so once it's received, an interpreter will be assigned and provided for you. So we appreciate your cooperation with that. And that is the end of our presentation. We'd like to offer you the opportunity to answer any questions you may have submitted through the chat.
Leon, we did have a question come through about transcripts and what transcripts may look like when you are using the services of an interpreter. Can you take us through that?
All right. When either audio or video is presented as evidence, the translator that's assigned the job will listen to the audio, presumably in the other language. That's why it's the translations being requested. Will transcribe first the entire audio. And once the audio has been transcribed, then the translator will prepare the translation of that audio in a second column. So there are different standards, but normally the standard is to have the original audio in one column and then the translation of that audio in the adjacent column. That allows for an easy way to review the transcription, to review the translation that's been presented. And that transcription and translation is certified by the translator who prepares it, and then is used in court as evidence. The reason that we cannot interpret audio or video in court live is because we cannot certify to the accuracy of that interpretation. I've worked on transcriptions and translations, and I can, and if you speak with court reporters who regularly prepare transcriptions, sometimes or often it requires listening to a certain segment over and over to get what was that word, to get the accurate transcription of it. There may be background noise, there may be two people may be speaking over one another. And so the transcription part is extremely time consuming and requires a repetitive process, and maybe even adjusting certain controls for volume to and equalizers to to quiet some of the background noise, and then perhaps raise what one's needing to hear better. That's something that we cannot do in open court, and so the bench guide and the national standard is, if we're asked to do that, we cannot certify to the accuracy because it's just impossible. But the more accurate way and the standard is to prepare that transcription and then prepare a translation. And then normally the translator makes themselves available if asked to testify to the accuracy of their translation. I hope that answers the question.
I think it does. And if there's, to get a little deeper into that, if there is a certain segment of the audio that the interpreter just can't come to a conclusion on, can't hear it well enough, how is that marked on the transcript?
One of the standards for a situation like the one you describe is to, in brackets, and normally brackets are used for a translator's notes or comments, so that anyone seeing the translation will know that that's a translator's note or comment. So normally the way that that's handled is in brackets to write the word unintelligible. So if it's something that no matter what resources we apply to, we just simply cannot hear the word or the expression clearly for whatever reason, we will not guess, we will write unintelligible.
Understood. Thank you.
You're welcome.
Well, I appreciate, I think that's the questions we had. And Leon, I appreciate you coming on and taking the time to be here with us today, providing that information. I know, especially here in Southwest Florida, interpreters, we put a lot of demands on your time and your abilities to help administer justice throughout the courthouse and to help those, our non-English speaking clients. So we appreciate everything you do for us here in Fort Myers and Lee County and all throughout the 20th Judicial Circuit. So thank you.
Thank you very much, Matt. And I just want to reiterate that it's our pleasure to serve the courts and the clients and the people that we serve to give them equal access and ensure due process. And we appreciate all the work that you as attorneys do in this process, and we enjoy very much working with you. So thank you again for the opportunity that you've given us and the interpreters department to express this by way of this presentation today. Thank you.
Great. Thanks a bunch, Leon. Just for a reminder to everybody, we are recording. This will be available on YouTube for watching later. And please keep an eye on credentials for CLE credit coming up when this gets certified from the Florida Bar. So thanks, everyone. Enjoy your Friday afternoon. Have a great weekend.
Thank you.